Hello, hello, hello. Happy Thursday. This is Latavia, your business and legacy attorney. I am here to talk about, as I mentioned in my flyer, I'm going to talk about trademarks, but primarily because one of my goals is to make sure that business owners or individuals in general are protected, that I am here to help you build and protect your legacy. So with that, one of the key components of doing that is having federal trademark registration. So if you have a business, if you have a hobby, a service, or any type of good that you're selling, then you want to make sure that you register for federal trademark protection. So at the outset, I always like to give people examples of what a trademark is, or ones where you might not necessarily know that it was a trademark or have the terminology for it, but you recognize it. So I always love people to think, when you're talking trademarks, think of your brand. So examples would be McDonald's, Nike, their phrase, just do it, Microsoft, Mercedes. If you can see behind me, my printer is an HP printer. That's their HP, in that little kind of circle is the logo that they have. So in essence, what is a trademark? So the legal definition of a trademark is a word, phrase, design, or symbol that identifies the source of a good that's being provided, and it distinguishes it from one party to the other. We also have a service mark, which is essentially a word, phrase, symbol, or design that identifies the source of a service from one party to the other. Now, one covers specifically goods, the other covers services, but commonly they're referred to as a trademark. So if you hear trademark, just think goods and services. So why do you need a trademark? Why is it important? Why am I sitting here talking about this? The reason that you want and need one is because filing for federal trademark registration gives you actual ownership as well as protection of your business name or brand. Like I said, some of the examples that I was talking about with Nike or Microsoft or Adidas, even Puma. If you are a fan of college sports or sports in general, if you see, like, I went to Temple for undergrad, and I believe at the time they were sponsored. At one point they were Adidas and then Nike, but in order to use Nike's logo or their name, the university has to get a license for that. So I'm getting a bit ahead of myself, but one of the things, like I said, is in addition to owning it, you are able to make sure that if someone else decides that they want to use it, they can't just go and use it. They have to pay you to use it, or if they don't, then of course that's when you have the right to send it what you call, or if you've ever heard of, a cease and desist letter. So I'm going to back up a little bit to talk about essentially how you get federal, what trademarks are, how they work, in terms of there's a common law protection, and the way that works is if you are using your name or a logo, a phrase to represent the services that you provide or goods that you provide, then you have what's called a common law trademark protection, and that's where if you've seen someone put the letters TM behind their business name or a logo, what that does is it's putting the public on notice that, hey, I'm claiming my common law right, or I have filed for federal trademark registration but have not yet been granted that registration yet. So with the common law, like I said, it only covers your local geographic region. So for example, I live here in Maryland. One of my phrases that I use is build and protect. Let's say that I do not file for federal trademark protection, but I use build and protect, and behind it I put that TM. If there's someone else who decides they also want to use that phrase and they take the steps to protect it through federal trademark protection, even if they do it a year after I've started using it, they now have priority, because once you have that federal trademark protection, it covers the entire country, whereas mine is only for the small geographic region. So I might end up losing out on the money, time, and energy that I spent in building that brand. So how do you obtain federal trademark protection? So the primary way is you would file for protection through the U.S. Patent and Trademark Office by submitting an application. So examples of things that can be trademarked, because unfortunately not everything can, but so like I said, a business name, a logo, the signature of an event, clothing brand, a stage name, a nonprofit name, a title of a book series. And so, for example, the chicken soup for the soul, like that has become a series. So I'm pretty sure that chicken soup for the soul, they now have a trademark, or if they have not, that is something that they could apply for trademark protection for, because it covers the entire series, not an individual book. So if you only have a single book and it's one title, then that's not something that would be eligible for trademark protection. It's something that you could potentially get copyright protection for. So examples of some things that you cannot get trademark protection for would be an idea, a concept, a t-shirt design. So, and I've had this come up with clients often where maybe they just put their business name or logo on the front of a t-shirt and they want to sell that. So that is considered a design. That's not a clothing line. So if you just have a single design that you are putting on t-shirts, and whether you do it in multiple colors or whatever, that is not something that would be eligible for trademark protection. If you wanted to essentially get or secure trademark protection for it, then you would need to show how you have a series or a line of clothing or apparel that all bear the same mark. So going back to Nike, they make a variety of apparel and accessories. They have shorts, they have shirts, sweats, headbands, all those things. But regardless of the design that is on those apparel items, you are always going to see either the word Nike or that check mark. And so that's showing how they have created a line. Another thing that would be difficult, or you cannot get trademark protection or may be difficult, would be a generic word or phrases. So if it's something that has become so common that it's generic, then they're not going to grant trademark protection for that. So as I mentioned, if you're using your mark and you have common law, like if you use that TM, once you have actually secured federal trademark protection, you can then begin using the R in the circle. So if you can see, I don't know if you really can, on the shirt I'm wearing, it has the shield of my sorority, Zeta Phi Beta Sorority Incorporated, which they have taken the steps to file for federal trademark protection. And this is our shield. It's so considered a logo or design, but right underneath it, there is an R in a circle because they now have federal trademark protection. So like I said, once you have that federal protection, it covers you throughout the United States. So just some of the other benefits, like I said, in addition to having that nationwide protection, it gives you, rights to use the R symbol, as well as you can pursue statutory damages in court. That's what gives you the legal standing to send a cease and desist letter if you learn that someone is using your mark inappropriately, or let's say even if you have granted someone a license and they're using it, they are not following the guidelines of their licensing agreement. So just some additional benefits is, like I said, it prevents someone's good faith defense. So it's like, hey, I really didn't know that this existed. I came up with it. I just wanted to use it. Yeah, well, sorry, I have federal trademark protection, so that's on you for not taking the time to learn because it's protected. And it also discourages others from using confusingly similar marks. One of my favorite movies is Coming to America. If you've seen it, it was in both, but specifically in the first one, they talk, where McDowell's. They kind of alluded to it when Akeem and Simi first started working there, but how, those people from McDonald's, they keep coming down here, want to talk about, but essentially McDowell's was infringing on McDonald's intellectual property, but they they said, hey, we're not copying it exactly. You know, our M is a little different. They have sesame seeds on their buns, we don't. But realistically, if McDonald's were to have taken legal action, McDowell's would have had to shut down, because although they were not copying it directly or doing things exactly the same, they were doing it in a way that could be considered confusingly similar. And that is one of the things that having trademark protection protects you from, is although they can't just come and do the same, take your stuff exactly the same, they also cannot get protection or registration for something that would be considered confusingly similar. And essentially is, if I am driving down the street and I were to see the M, from a distance, and it was actually for McDowell's, it's a strong probability that if I see that from a distance, I'm pulling up, in my mind, I'm thinking it's McDonald's. And then when I get there, I might be disappointed because it's McDowell's and not McDonald's. So that, like I said, that's an example. So some of the different types of marks that they kind of classify things or categorize things in would be a descriptive mark. And so a descriptive, it literally just describes a quality or ingredient of it. So examples would be Coca-Cola or American Airlines. So when you're thinking about coming up with your name or logo or a phrase that you would like to use as a part of your brand or for your business, there's, kind of with everything else, there's levels to this. So in terms of the greater protection and greater likelihood of receiving registration, think of it as kind of almost like a pyramid in level. So the lowest level would be something that's generic, where it's either you're just not going to get protection at all, or it would be very difficult to protect it from others. There's descriptive, then there's suggestive. So an example of something that would be suggestive would be Netflix, because, Flicks, they have shows, there's movies. It's not necessarily in the name, but it implies what it could be about. Arbitrary is something that is almost completely made up, and it has no connection or relation to the service or goods it's the source of. So an example of that would be Apple for computers. Prior to Apple, opening and becoming this big household name that it is, we would not associate a computer with an Apple. Completely different. And then fanciful is something that is kind of, as it implies, fancy. It's made up, it's created. It has no meaning in the English language. So an example of that is Kodak. Now, of course, nowadays, at least for most of my life, I have associated Kodak with cameras and film. But prior to them creating their company and building their brand, that was not something that was associated with it. So something like Kodak has very strong, it's a very strong mark, because it's, like I said, completely created. It has nothing to do with the product or service that's being provided. So it makes it that much more difficult for anyone else to come in and try to receive trademark protection for something similar. So just getting to actually, in terms of kind of the process of applying for the trademark. So when you're submitting your application, there's primarily two that is going to apply to most of us, and that is a use in commerce or intent to use. Now, use in commerce, like I said, it means you are actually using it. You are already holding it out to the public, providing the service. If you're selling goods, you have a website, people are able to go on the site and order things, or you're advertising your service, you're providing the service, and there's a way for people to actually purchase or book your services. Now, if you're applying for trademark protection on a use in commerce base, some of the things that you need to be aware of is, once you're submitting that application, one of the requirements is you need to show or provide an example of the actual mark or logo as it is. So it needs to be full color, or if it's black and white, whatever it is, you need to submit that to the trademark office with your application. In addition to providing, your information, you're going to explain what it is, why you're using, how you're using it, how long you've been using it. And then one of the other requirements when you are applying for use in commerce is you want to show or need to provide an example of how you're using it. Now, the Patent and Trademark Office, they call this a specimen, but I like to tell people it's an example. So if you, for me, I'll use myself as an example with my law firm, I'm providing a service. One of the things, so there's different types of specimens that can be provided. So for me, it can be a screenshot of my website. It could be a business card, describing the services that I provide. It could be a flyer that I have created, showing, hey, these are the services, this is where you can obtain them, and my logo or my mark is displayed on them. If you are selling goods, then you need to provide an example of the goods you're selling. So some examples from my clients, I had someone who's provided a hairline. So the specific packaging she used was a bag. So we provided pictures of the packaging that the products came in. And so the logo was displayed on the front of the bag. Now, something to keep in mind with that, if you have a mark or logo that you are using and you specify colors, which you can do, you have to make sure that the specimen or the example that you're submitting to the Patent and Trademark Office looks the same as what you're saying you're submitting. So for example, if I say my colors are purple and orange, and then I submit an example of my business card, but it's in black and white, then that's not going to work because it doesn't match up with what you're saying the actual mark is. So if you are going to claim color in your actual mark, you have to make sure that what you submit also includes those colors. Now, you don't have to claim a color, but like I said, that's just something to think about. Now, excuse me, you also have to identify the class of goods or services. So the Patent and Trademark Office breaks trademarks down into international classes. So there are some, and they have numbers associated with each one. I call them, it's maybe easier to think of them as categories. So you have categories for goods and you have categories for services. So when you when you want to submit, like I said, use in commerce, you have to have your actual mark, a drawing of it, an example of how you're using it, as well as specifying what type of goods or services you are using the mark for. Now, if you, and I see someone ask the question, what if you also want black and white and color? So yes, so you can, and I'll touch on this a little later, but yes, if you want to submit your logo in color as well as black and white, you can do that. You can submit as many variations of it as you'd like, and because the more that you have, the stronger or broader your protection is. So in going back, like I said, Nike is easy because if you think about it, they use multiple colors for their logo. So you can submit one in black and white and just saying, hey, this is it, and then you can use it whatever color you want, or you can submit a one where you specify colors. So those colors are a part of your trademark. So if someone were to try to use the same thing and use those colors, then that's automatic, like, hey, you're copying it. But even if they decided to do something, let's say someone comes up with a different name, but they use the same colors that you use, that is something that could potentially be deemed confusingly similar. So for example, if you think of FedEx, yes, we know the words FedEx, but we also know that they use purple and orange. So if it's some other company that decides to, I don't know, if they say Bromil or Broadex, something like that, maybe it's Broadex, but it's in purple and orange, it's a strong possibility that the Patent and Trademark Office is going to deny registration for that, because depending on how it looks, it could be the same as with McDonald's and McDowell's, where if I see it from a distance, or if I see it without, if I just kind of quickly glance, I might assume it's FedEx, but it's not. And so that's another example of how to think about it. So the other option for submitting an application is intent to use. So when you submit something on an intent to use basis, that means I'm not yet using it. I'm planning to. So if you think of like if you want to reserve a name, or I just want to put it on hold. And this works and this is something that I advise clients of. If you have not started, if you are thinking about it, but you haven't necessarily put a whole bunch of money into your branding and marketing materials, do this up front, because this way, although you have not started using it, you are essentially you're like, hey, I'm holding my place in line. This is what I want to do, and I want my protection to start now. So with an intent to use application, the process is similar, except you're not required to submit an example of how you are using the mark in commerce, because you're saying, hey, I haven't started using it yet, but I'm planning to. So if I had a client, they're just starting their business, they have a name, they got a logo created, but they haven't actually started yet. So what we did as a part of the process of them, we filed paperwork to create their LLC so that they're protecting their personal assets and reducing their personal risk and liability by creating a legal entity. One of the things we did in that process is file the trademark application before they've really started anything. So it's out the gate. They have laid the foundation to have protection from personal and financial liability, as well as making sure their business name and their logo is protected. So as they continue to build, they've already done that. So with the intent to use application, like I said, use same steps as use in commerce, except for you're not required to submit an example of how you're using it when you file the application. So with both processes, once the application is submitted, it's reviewed and assigned to an examining attorney. They review it, go through their database to determine, if it can be approved, if there are any issues or anything that would be deemed confusing to. If not, then they approve it for publication. Now, once it's published, with the use in commerce, once it's published, it goes through that publication period. If there's no opposition, then it's registered. You get your certificate. If it's an intent to use application, it goes through that same process. If it's approved, it's published, but at the end of that publication period, they then issue what's called a notice of allowance. They're saying, hey, it's been approved, you can use it. You now have 6 months to submit a statement of use. The statement of use is essentially saying, hey, you now need to give us an example of how you're now using it. So let's say you file now, that gives you that entire period to work and develop what you want it to look like, how you want it to, what you want to use it on, and you can then submit it. But one of the great things about this process, although it can take a while, and right now it's taking anywhere from like 8 to 10 months for applications to be assigned to examining attorneys. So it could take up to a year before you get that official registration certificate. However, your protection starts from the date that you file. So whether you file use in commerce or intent to use, if we file the application today, July 28th, then that protection starts today. So let's say we file intent to use today, and it's going to be a year or so before we actually get our official registration certificate. But let's say someone comes in a month later and files an application for on a use in commerce basis, and it's similar. Our application for intent to use is still going to be given priority because we filed it before that other one. So that's just like, because trademarks were kind of first in time, first and right. So, excuse me. So like I said, that is the process, a very broad overview of the process. And like I said, just want you to make sure you understand why you need it and how. And so some things to think about, and I like to call them cautionary tales, in terms of someone using their marker. They put all this money and time into it, and then they don't take the step to file for federal trademark protection. Is essentially, like I said, you've been using it, but somebody files before you. And I had a situation like this recently where someone reached out. They've been in business for several years. They're very successful. The brand is quite well known. They thought that because they had a domain name, they were good. However, recently they went to try to actually start the process of applying for trademark protection and learned that someone has already registered or has a trademark for their same name. Now there may be a way to make an argument that they're not the same, but that's just an example. Like right at this point, they're years in, however many dollars that have been spent on building it and developing this brand, and now they potentially have to come up with something different, which is going to cost more money. And then, like I said, so you don't want to be using something and be unaware that it's the same or considered confusingly similar to something else. So a big part of this process is before you submit an application is that you have a comprehensive search completed. And granted, this filing for trademark protection is something that you can do on your own. It is not required that you hire an attorney or someone else to do it. The reason that I strongly encourage and recommend people to hire an attorney to do this for them is because the search is a vital part of this process. Because if you do it on your own, you may not necessarily know all of the different nuances of conducting a search of the patent and trademark database. So you could do a very general search and it says, oh, there's nothing here, and you think that you're good. But then you submit the application, you go through the process, and then you get one of those dreaded office action letters, which I'm not going to go too much into detail in, but essentially you get a notice from the examining attorney telling you, hey, this can't be registered because there's something exactly like it, or there's something that would be considered confusingly similar to what you were applying for. And then unfortunately, these application fees are not refundable. So you have not only spent money on, having it created and then getting materials made. You've also now spent money on this application fee that you can't get back. And now it's all for naught and you have to go back to the drawing board. So the goal is to help you avoid that. So that is, like I said, trademarks, a very, very brief kind of like nutshell of what trademarks are. And just some of the reasons, like I said, that why they're important. It's one of the things that I like to do personally and professionally is I want to reduce stress, reduce anxiety. And so by taking the steps to register your trademark, you go a long way in reducing stress. It gives you peace of mind and knowing that, hey, I've done that. I have a strong foundation. This is mine. I own it. Like I said, it stops others from profiting off of your brand. I saw a clip from a podcast. An attorney was talking about the fact that, kind of this phrase that is worth millions of dollars these days. And that phrase was, let's get ready to rumble. I'm sure you've heard it. I heard in wrestling. It's referenced in songs and movies, all types of things. But the person who created that phrase had the foresight to file for trademark protection however many years ago. And since then, they have made millions off of that one phrase. And that's something that we hear about passive income. And the way that that's done is I'm sure they licensed it. So you get to the point of, if you want to use this phrase, you have to pay me. And as the owner, you get to determine what the value of that is, how who can use it, how long they can use it, what the parameters are of them using it. And so that's one way where even if you're not, and I think I'll have to double check, but I believe Meg Thee Stallion, she had applied to have trademark protection for Hot Girl Summer, because if you remember a couple years ago, it blew up and everybody was trying to use it in their marketing and all these things. And so if she does, whoever owned it, that's something that, hey, you want to use it, great, but you're going to have to pay me. And we're going to have a licensing agreement to make sure that that's the case. That works for phrases. That also can work for goods. If you have a product that you made and people want to start using it, kind of white labeling it, you can license it. So there's a lot of advantages to not only, building your brand to be successful, but making sure that you actually own your brand and you own your intellectual property. Because if you don't own it, like I said earlier, you face the potential of having to stop using it or rebranding because someone has beat you to the punch. Excuse me. So like I said, if you are doing anything with your branding, you want to make sure that you get federal trademark protection. And this brings me to, I posted about this earlier. As I mentioned, I'm in a sorority, Zeta Phi Beta Sorority Incorporated, and our organization owns several trademarks that are affiliated with our sorority. I saw a post in a group chat, and I'm sure the person was probably joking, also serious, in the sense of, if you're not familiar, there's friendly rivalries or feuds, so to speak, between some of the fraternities and sororities. In this case, Omega Psi Phi Fraternity Incorporated and Kappa Alpha Psi Fraternity Incorporated. Both were founded in the year 1911. Completely different colors, different missions, but so there's this friendly, official, unofficial rivalry between the two. And the Omegas recently had their conclave or national conference. And I guess it was announced that one of the recent things that were done is they received, got trademark protection for the year 1911 or the numbers 1911. And so the post essentially was saying, the Q's trademark 1911. So now you got to ask permission to use it, and saying sorry to the Kappas. So if you're familiar with it, when I first saw it, I just thought, maybe somebody's just trying to be funny. But being the person that I am, I went and looked it up, and lo and behold, they did secure trademark protection for 1911 for, I think, 2 or 3 categories. So they are not the only ones with a trademark for the numbers or the word 1911, but what that they've done is they have secured ownership for, like I said, their specific categories, which those, for theirs, it's related to kind of nonprofit services, apparel, and some of the specific functions of the organization, the service component of it. And that category does have some overlap with the functions of Kappa Alpha Psi fraternity. And so it will be I'm curious to see how this plays out. But the reason I bring it up is because, like I said before, it's something that, it's a year. It's the year that you were founded, but both use 1911 in various marketing efforts or in apparel that's created, brochures, just different things. And so by Omega Psi Phi taking the steps to secure trademark protection in 1911, it gives them an ownership component of that, and like I said, in those specific categories that they have for their trademark. So if Kappa Alpha Psi has or was planning to start using that year in a specific way, then they are more likely than not going to be required to seek permission or essentially a licensing agreement to utilize it, or they will have to cease using it in commerce, whether it be to provide a service or to sell goods. Now, this doesn't mean that they have to stop saying when they were founded, because that's a fact. That's not changing. But if they had any type of apparel that they were official apparel that they were planning to release, or materials or services or an initiative that they wanted to, I don't know if they were going to have like a 1911 initiative, or if they even have one. Honestly, I don't know. But let's say that they already do. They have some program and it's a 1911 Newt Fund. I don't know, whatever the case may be. If they've been doing that and it is deemed to be the same or confusingly similar to the categories in which Omega Psi Phi owns the trademark for 1911, then they're either going to have to stop using it or rebranding or reach out to Omega to get a license. And like I said, one of the reasons I brought this up is it's interesting to me. My dad is an Omega. I'm in a sorority, and also just loving business and want to make sure people are protected. But it's interesting because I just left my sorority's national conference, and one of the things I spent time doing was in the vendors. And so people who, over the last few years, it's been in place for a while, but over the last several years, all of the sororities have been cracking down in terms of making sure vendors take the proper steps to get licensed to sell various paraphernalia that bears the logo or name of their respective organizations. And so you're not able to I can't just decide I want to start selling shirts and putting the Zeta shield on it or putting the Zeta name or Finder Woman, anything like that. I can't just decide to start doing that unless I could, but then I face legal and financial ramifications for doing so. But in order to do it properly, then I have to follow the proper channels to get licensed, to become a licensed vendor. And if any of you watched Insecure this last season, I'm also a big fan, there was a lot of uproar about the fact that the character Tiffany, I think it was I want to say it was the first or second episode, or it was one of the first few episodes of this last season where they had gone back to Stanford either for homecoming or some type of alumni weekend, and the character Tiffany was wearing a lot of Alpha Kappa Alpha sororities paraphernalia, and there was one where I think it was a cardigan or a blazer where it actually had the shield and not just the colors. Now, a little background, it had been established that Tiffany and Molly were both members of the sorority, but one of the big issues about that was that, to my knowledge, the show did not take the proper steps to get permission to utilize the shield or to utilize the name in the episode. And so I don't know if they have taken legal action or taken the steps to receive, proper compensation for that. But that's an example of, if you are going to use someone's intellectual property, and that's whether it's a copyright, a trademark, or patent, you can't just use it. You have to get permission to do that. It's the same. This is not trademarks, but thinking in copyrights, you think about sampling. Artists sample other artists' stuff all the time, but if they don't get the proper clearance, then they're infringing on that person's copyright or on that person's intellectual property and essentially cutting them out of proceeds. Because, hey, if I created it and I took the time to build it up and make it what it is, and then I get that brand recognition, best believe I don't want you profiting off of my work. And Lord knows there's enough of that goes around in this country. But I say all that to say, that's just a, I guess, more recent or current example of how it plays out, of when you think, hey, because I've heard so many times, specifically from new business owners, I'm going to get to it. Let me do these things first. Let me start making some money, and then I'll go back and I'll file for trademark protection. And as an entrepreneur, I completely understand that, yes, there is a lot that goes into creating a business and building it. There's a lot of money, so you have to, and unless you have a never-ending well of resources, you have to be smart and you have to be prudent about what you're spending money on and when. But I implore you to consider this to be a priority. While before you go spend all this money on deciding on what your marketing budget is going to be, what you're doing to building the website, all these things, make sure that securing a trademark is on your checklist of the priority things to do. Ideally, before you really start conducting business, selling goods, providing the services. If you're, for whatever reason, if you're not able to do it prior to, you need to do it as soon as possible after you start, because you want to make sure you are protected and that you own it because you don't want to end up in a situation where you are 6 months, a year, 5 years in, and then learning that somebody else has already filed for trademark protection and you're SOL. So you have to then decide, do I just continue doing this and run the risk of me receiving a cease and desist letter, or having to rebrand and spend more money? So I know people always talk about it costs so much, it's expensive, but it's better to take your time, spend the money up front, as opposed to end up spending more money trying to fix or correct mistakes you made in the beginning. So I do hope that this was helpful. There's a lot more that we could go into, but my goal today was just to provide, like I said, an overview of what trademarks are, the process, and try to convey the importance of securing your brand up front, sooner rather than later. This is one of my service areas. If you are interested, if you have more questions, you can use the link in my bio to peruse the website. I do have additional information there, or to schedule a consultation so that we can talk more about whether it's something you're thinking about doing or you're already doing, and how we can work together to make sure that you have a strong foundation with building your business and building your brand, so that you can build and protect your legacy. So thank you all, and have a great day.